a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
I love that song. David Whiting is, of course, a Melbourne solicitor here to give you some legal advice. Good morning, David.
Good morning, Raph.
You had some homework from last time?
I did. It was an interesting one. John from Camberwell had got a parking ticket for parking in a spot that was marked staff, and he said the sign was smaller than every other sign, and there were some people who texted in and said yes, but it would have been marked in yellow. So, and if he's got a ticket, the chances are that the council has resolved, or that the landowner, who may or may not be the council, has resolved that the road rules will apply to that parking space, because the concept of imposing private owner fines is incredibly difficult. So they normally delegate it to council. Now, and there's a provision in section road rule number 185 talks about parking in signs with permits, and the sign has to be a particular kind of sign. It needs to say permit zone, and if it doesn't, then the sign's not. So I would be interested if John could text in and tell us which was the road rule that is on the ticket, and also wonder what the sign actually says. It should say permit zone. If it's just an ordinary park says staff only, I think he should be defending himself.
You should be.
Well,
you don't get that advice often.
No. Look, to be really honest, Raph, I think there's staff parking for a particular reason. It's just to facilitate the operation of the centre. So I've got a lot of sympathy for whoever it is put up the sign, but I've got a fine. Is it justified?
Interesting. There you go. Let's kick off with Joe, who is in Bendigo. Joe, what's your query?
Oh, hello. How are we this morning?
Hi. Fire away, Joe.
I'm just curious about some of the parameters around death benefit payouts with insurance companies upon the death of their members. I have two children, both adults now, but at the time of their father's death, it was 3 years ago, they were in high school. So they have been named...
Did your partner have a binding death benefit nomination, or was it up to the trustee of the super fund?
He did have beneficiaries nominated there on his death benefit, but it did go through the trustees. There were other claimants.
So he anticipated, he said, I'd like it to be, but it wasn't a binding death benefit nomination, just a general nomination.
It was a general nomination, yes.
So in which case it's up to the trustees to determine. Yep.
Yes, that's right. So there were two other claimants that came through, and their claims were eventually denied. The problem was that this process took 3 years, and they wrote to me quite frequently to tell me what my rights and responsibilities were as the guardian of these children.
Yes.
And so we went about that to the letter meticulously. And unfortunately, they gave me some timelines under which they were obligated to act. They stuck to none of them, of course. They were impossible to get in contact with over the phone. Eventually, I had to find myself some legal representation to take care of it.
Yep.
Since then, it's been, I think that was 2 years ago.
Have you gone to AFCA?
Not yet, but we're almost there.
Almost at AFCA or almost finished, Joe?
Almost at AFCA, because an interesting development has occurred just in the last 2 weeks. We signed a deed of release 2.5 years ago for these funds.
Joe, we're going to run out of time.
Oh, sorry.
Yeah.
Okay.
No, that's okay. No, I'm just,
They paid one child, but not the other.
And they both above the age 18?
Yes, they are now.
Okay.
But at the time, they were still
under 18, yes.
Yeah. So they agreed to pay them as financial dependents, but only one has been paid and not the other.
Joe, what's the question?
So we can't understand, my lawyer and I, what are these timeframes? Do they have a legal obligation to wrap these things up in a timely manner?
They have an obligation to follow whatever the trust deed says. I wouldn't wait any longer. I'd just be going to AVCA. And I'd be saying that you want some compensation for the delay as well.
Okay. That was my thought too.
Yes. Yeah, don't wait any longer.
Good luck, Joe. Thank you for calling. Been there. Super. Not simple. Peter's in Ballarat. Go for it, Peter. What's yours?
Oh, look, g'day, David and Raph. I had I hired a car and got 2 camera speeding fines travelling to New South Wales, about an hour apart, but they're both on the Hume Highway. I stopped in between, 4 kilometres over each one. Anyway, I wrote to them and said, look...
Peter, has your car got cruise control?
Yeah, it had. Well, it was a hire car, so it was on cruise control on the right speed, but both lines were 4 kilometres over, so I'm assuming that the cruise control was out.
Okay, so your argument would be it's one episode of speeding. Raph and I know somebody who was on the Geelong Road. I won't tell him on air who it is, but who was on the Geelong Road and got exactly your problem. They weren't an hour apart, but same speed, 2 stretches of the Geelong Road, not high speed, but certainly over. And the argument was put that was, I did not slow down at that point. So you clocked me. It was one element of speeding, just clocked at 2 points. I think you've got a good argument.
Well, what they actually did, David, is they let me off one for the good record, but then the second one they said, no, because of your other one, we're not letting you off that one.
Yes, okay.
So, and then on top of that, they then, because it took 6 months waiting for them to get back to me, and in the meantime, they put another delay fine. I hadn't paid it, but but it was in process, and I wasn't delaying beyond reason or anything, but they put another $300 on it. And so my question would be, since I think that's a reasonable argument if I was in for a court, but I can't seem to get an option to get it in front of a court if I was to, if I write them saying, look, they've run out of options, whether I could is there a way I can get it in front of a magistrate?
How does he do that, Dave?
You just tell them you wanted to go to court. Because at the moment you're still in the negotiation phase. If the negotiations fail, they won't withdraw the fine, then you elect to go to court. Why not tell them you're ready to go to court now? But I don't know that you can expect the discretion that you got.
Yeah,
you're not going to get the discretion. I understand the argument for one fine, but I don't think that you're going to be able to persuade a magistrate that here's a guy going 4Ks over the limit for an hour or more. He's going to persuade the magistrate that, well, on the basis of your good record, we won't count it at all.
Okay.
Okay. Good luck.
Good luck.
All right. Thank you.
Thank you. Diane is in Seaford. Go for it, Diane.
Oh, hi, good morning. I'm just wondering, I'm an executor and beneficiary of a will, and I just want to know, it was my dad's place and he had it since the 50s.
Yes.
Do we have to notify the State Revenue Office?
Yes, you do. You've got to notify the State Revenue Office of the commencement of the administration of the estate.
Yes.
And if you're going to transfer that property to beneficiaries or sell it, they'll find out at the time that transfer occurs, but they will give you up to 3 years with the principal place exemption from a land tax perspective. But yes, there's an obligation on you to tell the State Revenue Office that the property is, that you're now administering the estate and the person it was registered to has died. But you normally do that when you get probate.
Yes, which I have.
Yes.
So that's okay. And it'll probably be exempt, being the principal place of residence.
Yeah, it sounds like it is, yes.
Okay. Yep, okay. Now, what about a letter to the beneficiaries? What should that include?
It depends on what the beneficiary is entitled to and what you want to tell them. If there was a will that says you're entitled to $10,000 from Dad's estate, then here's a copy of the will, and I'll give you some indication as to when you're getting the 10 grand, right?
Yep. So,
on the other hand, we're talking about a residuary beneficiary who's entitled to a share of what's left, then they're entitled to say, here's the will. I would be telling them, here's the will. This is what I think the assets of the estate are, and this is how long it's going to take me to administer the estate.
Okay.
So it depends upon where they fit. If the gift is $10,000 under clause 3 of the will, then they don't need to know he was worth $10 million or $20 million or whatever it is. They just don't need to know.
Okay, but they do need to have a copy of the will?
every person who's named in a will or in an earlier will. So even if your dad had a will that says, I'm not leaving Raph Epstein a penny, he's therefore entitled to a copy of the will.
Okay, that's good. And a tax return. Dad he's 92, hadn't done one for years. Do I have to do it?
Probably not. Depends on the level of income. If your dad had some shares that result in a taxable capital gain, yes, you do. But if he doesn't fit into that category, he had
probably doesn't
a house and $100,000 in the bank, you probably do not need to lodge an income tax return.
Good luck, Diane. Thank you for that query as well. We all learn a lot doing those sorts of things. George, you're in Brighton. What's your query?
Hi, good morning, Ruff, and good morning, David. My question is, if I want to gift my son some money that he could purchase a house, is there a limit to the amount, and is it taxable? Would I need to have a contract with him?
There is no limit. You sound like a very generous father. There is no limit. He could also buy in Brighton if you're generous enough. George, you don't need a document to record it. I probably would get some kind of note acknowledging that he's received the money and it was a gift. I'm just thinking down the track he may enter into a relationship with someone, and the question then rises is who's contributed the funds to the relationship. So there's no limit and there's no tax on receiving the money. If you've got to sell something in order to give him the money, there may be tax as a result of your sale, but not as a result of the gift.
And there would be no income taxable for him?
No, presents don't yet attract income tax. But who knows what will happen in the future, but, they don't.
Okay, well, it's an easy transaction. Thank you very much for your advice.
Thank you, George.
Good luck, George. Good luck. And John is in Clayton. John, what's your query?
Oh, hello. Thanks for taking my call. My query is if the Victorian Institute of Teaching, the VIT, if they say that they've formed a reasonable view that a teacher has a particular illness,
yes.
Where does the burden
and
of
therefore
proof lie?
affecting that person's registration as a teacher?
Well, affecting their ability to re-register,
Yes,
not necessarily affecting their ability to teach, but impacting their ability to re-register.
But it's
Who
like
has the burden
it's
of
like
proof?
you can drive without a driver's license. Just you need a driver's license to drive. Who bears the burden of proof? You need to prove that you need to get the VIT to form a new view. But if you're not happy with the decision reached by the VIT, you can go to VCAT. Right? And you can argue to VCAT that in fact the view held by the VIT is not right.
So I assume that to do that, you have to get you have to organise your own medical practitioner to examine you and write a certificate saying that.
Well, John, the VIT will have some evidence that caused them to form the view. You've got to get to the point where you can persuade someone else that, taken as a whole, the evidence provided by the VIT or used by the VIT shouldn't have led to that particular outcome. So the tribunal will make a new decision based on information that includes what the VIT has. And if you simply come along and say, well, I hear what they're saying, but they're wrong, you're just not going to get anywhere. You've got to produce some evidence that would indicate a different outcome.
Good luck, John. I'll get to more of your calls with David Whiting in just a moment.
When we go to the show, there's generally quite a few flies around the livestock section.
If we didn't have flies, we'd actually be waist deep in poo and rotting animals. So the larvae are really essential nutrient recyclers.
Trevor Chappell.
So if you go to the show, realise it's actually helping the environment.
That just sounds like an Aussie summer, like the show, cows, flies, the smell of poo, eating a downward dog. It's all good.
Afternoons with Trevor Chappell.
On ABC Radio Melbourne and the ABC Listen app.
You're with Raph Epstein on ABC Radio Melbourne.
My name's Raph Epstein on the mornings program. Of course, we are continuing with your free legal talkback with David Whiting. We do this every Tuesday morning, 1300 222 774. David was here before I think anyone else was on air, and he'll likely be here after anyone on air is still on this radio station. Forgive me, David. I mean that. That's a compliment. Okay, it's 100%. It's 100% a compliment. Let's have a chat to Damien, who's in Pakenham. Go for it, Damien. What's your query?
Yeah, I was just wondering that there's a problem with water running off from a block that's 500 mils higher than the block behind it, and the developers have put in a drain in the block behind it, but the block behind, the fella keeps complaining because obviously the water's running off, and it's sitting because it's high plasticity clay. It's not going anywhere.
Damien, can I ask, why is it 500 mil higher? Did somebody raise the? Is there fill on one block, or is another block being excavated?
Yeah,
or is it just the general slope of the land?
Yeah, the back block has been excavated because the higher block there's rock at about 500 or 600, and then at the back block the rock's further down, so they've excavated it. And the homeowner at the back has put in a retaining wall that's 400 mil high, but he hasn't put any aggie pipe or anything like that in, and so the water's
just
running.
Just put in a berm or a dam to prevent the water flow.
Yeah.
But
it's not working. It's going straight underneath it, and because it's the water can't go anywhere because it's like the same sort of material that you would make a dam out of.
Okay. If someone does some works that interferes with the natural flow of water, they can be liable in damages and can be asked to remove it. It's a VCAT claim. Claims under the Water Act go to VCAT, but your argument is that you've interfered with the natural flow of water and I've got loss and damage. I want you to fix the problem.
That would be the developer would be taken to
whoever's complaining about the water flow.
They would take the developer, yes. Okay.
Yes.
Makes sense?
No worries.
Yes.
Yeah, I understand that. Thank you very much.
Thank you.
Good luck, Damien. Good luck. Paul is in Moorabbin. Go for it, Paul.
Yeah, g'day guys. Thanks for taking my call. Just wondering, de facto couple separates. It's been about 4 years. Is there still a claim available for financial settlement, or is there a time frame where you've got to get that all actioned?
When did the relationship come to an end?
2019.
I think that person's out of time to bring a claim.
Yeah, from what I was reading, I was thinking the similar kind of thing. But yeah, look, thank you very much. I'll go and find a family lawyer and have a chat to him.
Okay, and for everybody else, I'll confirm the consequences next week. No children?
Yeah, children.
Okay, you just complicated things slightly, Paul, but okay.
Yep.
All right, so there are children. Are the children underage, presumably?
Yeah, they are.
Okay,
yeah.
All right, next week. Thanks, Paul.
All right, thank you, bye.
We'll look it up for you, Paul. David will take that as homework. Ian's in Ocean Grove. Go for it, Ian. What's your query?
My query is with the deceased estate, two issues. One, if a house was bought in the 1970s, is no principal residence anymore, does that still have capital gains tax applied? And secondly, what is the consequence of
the property's been owned before 85?
Correct.
No change in ownership. Are we talking about an estate or somebody who owns it selling it?
I'm talking about a deceased estate.
All right. Now, what happens, and it's more than 2 years since death?
Not yet.
All right. Then provided it's sold, and I don't mean settled, but I enter into a contract within 2 years, and for the whole of, or since 1985, it has been the deceased person's principal residence, no capital gains tax.
And what happens if we go beyond 2 years?
Then you'll need to value the property at the date of death, and there'll be capital gains tax payable in respect of any gain in value between the date of death and the date of the next contract of sale.
Mm-hmm. Thank you.
Pleasure.
Good luck. Hopefully that answers you. Sounds like that does answer your question. 1300 222 774 is the number that Michael has called from Brighton. Michael, go for it.
Good morning, David. I have a tree in my garden next to the fence, and some of the high up branches are hanging up over a neighbour's property. He wants them removed. That's no problem for me, but the question is, if it involves a professional tree-cutting business with chainsaws, etc., because the branches over his place are so high up, who pays?
You do. They're your branches, Michael. Sorry. Yeah, okay. The answer is they're your trees. The law was created at a point where, I don't know, maybe properties were bigger and you could plant a tree that only ever shed leaves and had branches over your property. There is no... The general proposition is what's yours should be inside your place, including the branches.
Okay. No alternative?
Well, you could do a deal with your neighbour. I mean,
you could ask the neighbour.
I rather like having trees. I think they add to the aesthetic and they're good for you. But they're your branches on your tree hanging around in his place.
Okay. We'll leave it at that, and thank you very, very much.
Thank you, Michael.
1300 222 774. I think we've got another tree issue. It might be the person on the other side of the fence. I don't know. Tony, you're in Camberwell. What's your query?
Thanks. Yes, David, I wanted to ask, I've had a significant tree branch fall off a gum tree that's just been pruned on a neighbour's tree, and it's fallen down and hit our studio, our backyard studio, and damaged it. Is that a claim through my insurance, or is it approach the neighbours and they put a claim through theirs?
I would be approaching the neighbours, put a claim through theirs, but you also might notify your insurer just to make sure that if they don't process the claim or it doesn't move fast enough, you might choose to make a claim on yours.
Fair enough. Thank you.
Pleasure.
Are they okay with you claiming? Have you asked the neighbours, Tony?
No, I haven't. It just happened last night, so I'm in the process of starting up that negotiation.
The problem, of course, will be, because the trees have recently been trimmed, is that we're now going to involve the tree lopper as it's not just something that happened, it's something that the tree lopper did which caused the branch, more jobs for lawyers.
Oh, gosh. Someone else asking, the gentleman earlier who called about gifting to his son was George, I think, in Brighton.
George from Brighton, yep.
Someone saying on the text, he does need to let Centrelink know if he, the gifter, is receiving anything or will be in 5 years.
Because the gifting rules are $30,000 in 6 years or up to $10,000 in a year.
Right.
But provided it's not more than $30,000 in 5 years, then you can do that without getting your pension affected. But I'm assuming that George is giving his son enough money to buy a house, which would indicate slightly more than $30,000.
Indeed. And Dale will get the final question in Pascoe. What's your query, Dale?
G'day. Look, my wife left me about 7 years ago. She left me with 4 teenage girls, 2 dogs, a cat and some chooks. But since then, she's never made a claim for money or the house or anything. Is there a time frame where she has to do that?
She still has... I take it you're the co-owners of the house?
Well, it's in my name. I found out recently it was in my name only, but...
Oh, wow. Then she's entitled to bring a claim within 2 years of it. Are you divorced?
No.
Okay, then the answer would be yes, you still run the risk of a claim because you can bring a property claim within 2 years of a divorce.
All right.
All right?
Within 2 years. All right,
Yes.
Thanks for your help.
So just stay a bit quiet, Dale.
Yes.
Yes.
All right. Thanks very much.
Thanks a lot, Dale. David Whiting, thank you very much. We'll see you next Tuesday. David Whiting's here every Tuesday giving you some free legal advice.